All right, good morning, everyone. Welcome to another Launch Minnesota Friday Forum. We host these on the fourth Friday of every month, always on a different topic affecting founders or the
I have
Minnesota
a
state.
dog. She's friendly. Okay.
One particular thing that impacts a lot of startups and founders is, of course, one of the things that's most vital to any company is their intellectual property, the creative assets that set them apart from their competition. So that's one of the reasons why I am excited today to welcome Marilyn Nash and Darius Banks with the USPTO office. And they're going to be sharing some information with us about the resources that the PTO offers as well, and then answer any questions that you might have for your business. I will hand it over to them to get us started.
So good morning. I'm hoping I can share my screen. I'm going to try. Please let me know once you can see it. And then I'll do some introductions after that, just to make sure I can share my screen and we're good to go there. Can you let me know if you can see it?
Looks good.
All right. So again, good morning, and thank you very much for allowing us to be a part of your conversation today. My name is Darius Banks. I am the Midwest Elijah J. McCoy Regional Outreach Office Director. I am joined by Ms. Marilyn Nash. She is assisting me in the role of Assistant Regional Director, and she's also a Regional Outreach Officer for the office. So I want to say kudos and thanks to her. I may be tagging her in, if you will, at some point, maybe to answer some questions or to help me throughout the presentation. With that being said, the Midwest office is located in Detroit, Michigan. We're right off of 300 River Place Drive, Suite 2900. So please come see us. And I'll have some more shameless plugs throughout this presentation on where we are and who we are. But with that being said, let's get into it. Before I start, though, I just wanted to say, to frame it out for us, I'm going to start with kind of a patents overview, and then kind of get into the resources. And then again, as Maddie said, we'll get into some questions. But I want to kind of, if you will, establish a baseline if we could. So with that being said, and before we even go any further, again, what we're talking about today is not intended as legal advice. We implore you to consult a legal authority, whether it be an attorney, agent, however you choose, when it comes to specifics around your application or your IP that you want to have. All right. So let's get into real quick. The United States Patent and Trademark Office is an agency of the U.S. Department of Commerce. It's responsible for issuing patents and registering trademarks. We also advise the President of the United States, the Secretary of Commerce, and the U.S. government agencies on intellectual property IP policy issues, including patent and trademark copyright policy. Just to make sure we're still sharing, we're still good, right?
Yes, looks good.
Okay. Thank you. Again, the Elijah J. McCoy Midwest Regional Outreach Office is located on 300 River Place right here in Detroit, Michigan. There are actually 4 other regional offices, one in Denver, the other in San Jose, one in Dallas, Texas, and there's actually one located right in on headquarters, the Eastern Regional Office. We also have a community outreach office singular, located in New Hampshire. So again, we talked about, and I wanted to establish this kind of, if you will, baseline. When you talk about intellectual property, there's kind of larger buckets. There's utility patents, there's design patents, there's copyright, there's trade secret, and there's trademarks. I'm here today to talk about patents and kind of that trade secret. I'll let trademarks. If you want to call me back later, we'll talk. I'll bring some friends and we can talk more on that. But let's get back to utility patents. What's protected? Inventions. Examples, iPods, chemical equations, formulas. The protection lasts for 20 years from the date of filing that regular patent application. We'll get into regular patent application. Design patent is ornamental. A unique shape of a guitar, the shape of a car, lasts for about 15 years from the date of grant. A copyright, you're looking at books, photos, music, fine art, like Michael Jackson's Thriller music. The life of the author plus 70 years, excuse me. Trade secrets, formulas, methods, devices, or compilations of information. The Coca-Cola formula, KFC's original recipe. last for as long as information remains confidential. And then again, I said trademarks, I will bring back some friends, but that's words, symbols, phrases, designs, slogans that identify or distinguish products and or services. Coca-Cola bottle, for example, the Pillsbury Doughboy. Okay. So let's get into patents. What is a patent? A patent is a property right granted by the United States government. It is not worldwide, though. It excludes others from making, using, offering for sale, or selling the invention throughout the United States or importing the invention into the United States. It does have a limit to protection. We just stated 20 years, and it requires full disclosure of all invention details to the public. There's a process. There's a process from ideation, the time when you determine you have some type of intellectual property, to that maintenance period once you've gotten protection via a patent or trademark, or even you want a trade secret, and that's another discussion. But there is a process, a timeline, and we'll get into that as we go through these next couple of slides. So what is patentable? What is patentable? A product, a method of using, a method of making, a chemical composition, improvements thereof. But how do you know? It has to be new and non-obvious, it has to be useful, and it has to be clearly described. Okay? What can't be patented are laws of nature, physical phenomena, abstract ideas, literary, dramatic, musical, and artistic works. Remember, that's copyright, not patents. Inventions which are not useful or offensive to public morality. Again, path to a patent. Once you kind of determine what your invention is, then you have the option to file a provisional application or a non-provisional application, and then hopefully achieve that patent. And we'll kind of get into that again over the next couple of slides. Provisional versus non-provisional application. A provisional application can establish an earlier filing date. It has no claims, it's not published nor examined. You have 1 year, though. You have 1 year to pursue a non-provisional application, and it permits the use of patent pending. A non-provisional application specifically includes a description, a specification, and claims. Drawings are required. It is published and it is examined, and it may result in a patent. So parts of a non-provisional utility application, again, non-provisional. It has to have an abstract, a short summary of the invention, a specification. How does an invention work? How is the invention made or used? And it has to have drawings if necessary. What does the invention look like? What are the specific aspects that you're claiming? Filing your application. Again, there's a couple different ways to do this. You can file as a pro se, that means yourself, or you can hire a patent attorney or agent to support or help assist you. You have to submit all your paperwork online through the Patent Center by uploading that documentation, and you have to pay a required fee or fees. And you receive an application number and a filing date. So once you submitted that application, you've gone through that process, what happens next? What's behind the iron curtain or the green curtain or the emerald curtain, if you will? That application goes into a hopper. That hopper creates a technological profile based on its technology, whether it's chemical, electrical, mechanical, or biotech, or biochemical. And then it goes to, if you will, technology centers. Those technology centers have technology examiners. Those examiners are broken down again into the disciplines, chemical, electrical, mechanical, or biotech. Once those examiners examine that application, again, happy path is to a patent. But that's kind of what happens behind, if you will, that emerald curtain once you filed your application. So let's get into more of the roadmap. Okay, so you know you filed it. Then kind of what actually transpires. You go onto, if you will, a highway, an examination highway, using that analogy, as you can see on the screen. That examination highway leads you to an off-ramp. That first off-ramp is where the examiner picks up that application. The examiner then examines that application and determines whether there's any rejections and or objections to that application which is filed. That information, via what's called an office action, is then put back onto that road, and it takes another off-ramp. That off-ramp goes to the applicant, back to the applicant. The applicant at that point and or representative have the ability to, if you will, amend or argue those rejections and or objections. And then it goes back onto the highway, takes that off ramp again to the examiner. And the examiner then at that point can submit a final office action to those amendments and or arguments with additional rejections and or objections appropriately. Now, one or two things can happen. Once it goes back onto that road and goes to the applicant again for the final time, the applicant at that point can choose. They can choose to either accept, when I say accept, agree with those objections, and do what is necessary to take that to an allowance. They can choose not to and abandon, or they can choose to appeal those final rejections, that final office action made by the examiner. But again, the happy path on the examination highway or avenue is straight to allowance boulevard. So what happens post-grant? Post-grant responsibility. You must renew a utility patent without surcharge at 3.5, 7, 7.5, 11.5 years after the date of issuance. You cannot pay early. There are no post-grant fees for design or plans. Okay. Some benefits of a patent: attract lenders and investors to obtain funding, establish a business to market, sell, or license the invention, or you can assert or enforce rights against infringement by filing with the U.S. Customs and Border Protection. So let's get into some resources. There's a couple of slides here on resources. I'm going to actually walk you through. I'm going to escape, and hope I can do this without messing up. And Maddie or anyone, let me know if you can still see my screen still. I think I'm still sharing.
Yep.
Still sharing.
Perfect. When you go to uspto.gov, so I want to show you a live kind of what happens. When you go to uspto.gov, and you can see on the screen up here, when you go to uspto.gov, there is a section for right here for new to intellectual property. Everything from patent basics, trademark basics, right here for you. I won't get into it right now, but I will want to talk about this: identifying what kind of IP you have. It's called an IP identifier tool. That tool is going to walk you through about 6 questions. Those questions help you identify what type of IP you have, whether it's a patent, whether it's trademark, whether you should maybe think about a trade secret, or whether it's some having to do with copyright. It walks you through those questions. And then even it has an advanced tool, which can even take you through additional questions. What I do want to show you, though, is right here, Inventors and Entrepreneurial Resources. Those resources are there available to you. Everything from getting started, the types of IP protection, again, that IP identifier tool I just talked about, to the patent, trademark basics, copyright basics. But what you should think about before you apply. Again, we won't get into your business strategy or business plans, but more so from an intellectual property standpoint, what you should be thinking about when you're looking at searching for patents or trademarks before you apply. Is there something already out there? Novel, non-obvious, useful. Is there something already out there that would preclude you from getting that patent, trademark, or registering that trademark, or getting that copyright? So things you might want to think about are there. Everything to protecting yourself against scams once you've secured that patent. And even funding. I know some are thinking about funding. We are not a funding agency, but we do provide resources in the sense of directing you to where those funds may be located through SBA, SBIR, STTR, and other avenues there for you. Okay. So going back and looking again at access to our free services, there's a plethora. There's a plethora of free services. You can look at it from a patents perspective, a trademarks perspective. You can look at it from a list view. You can look at whether or not you want just learning the essentials, preparing to file, applying for protection, whatever you want to slice and dice, legal assistance, one-on-one, self-guided learning. It's all there for you. And again, it's all free. If you need assistance with kind of even deciphering this down, again, we are here for you in the Midwest, but there's also something called the Trademark and Patent Assistance Centers, which can assist you with, if you will, walking through some of your finer questions to help you get started, okay? And then one last thing I want to bring up, and then I'm going to allow if Marilyn wants to speak. Maybe I missed something before we get into questions. The last is USPTO locations. As I said before, there's multiple locations throughout the country, regional offices to be specific throughout the country. But there's also patent and trademark repository locations throughout the country. And again, all here to assist you. Again, these buttons are just showing different locations, but please avail yourself to that. The patent and trademark resource centers are invaluable tools. They're located in libraries throughout the country and also on university campuses. And they're there to assist you with questions you may have in regards to either filing of your patent application. And I want to be clear, they're not there to provide legal advice, nor I just want to be clear on that. They can help you in finding or searching, but they're not, again, there to provide any legal advice. So at this point, I am going to stop sharing, move you guys over here so I can see you, and then turn it back to Maddie.
Cool. Thank you so much, Darius. Well, it looks like Peter has a good question in the chat here. Peter, you want to tell us a little bit about your question?
Yeah, it's kind of long, but yeah, when we filed our provisional patent application January 2024, we felt pretty good about the paperwork that we filed with it, and then the lawyer took our 10 grand and made something that was almost incomprehensible to us. So we're a little concerned that, one, it's not going to provide the protection because it's not clear. But then on the other hand, maybe that's to our benefit if other people can't understand it too. I don't know. It's my first time going through it.
Okay. And I should have prefaced this. And so where I kind of gave you where I currently am, where I sit as far as my professional, but let me kind of give you and preface your question with saying my knowledge depth. Okay, I was a patent examiner. I came in back in 1994. You can do the math. I'm pretty old. I came in as a patent examiner in the mechanical arts and also did some electrical stuff. So I came in as a patent examiner. I then became a supervisory patent examiner. Then became a technology center director. I did some international work for classification for the office, and now I am here. So in prefacing your question, I'm going to start with, and I would tell any of my examiners this, I can't provide you legal advice on how your attorney may have or may not have filed or written your application. I will say this, and I think this is true even when filing a copyright. You want to have some, you don't want to have a patent that is so narrow that everyone can innovate over. But you want to have a patent that is specific enough where it identifies not only your invention, but provides you protection for that invention and allows you to build upon it, right? Because it's the innovation, it's ideation, right? Ideation continues; it doesn't stop. So I would again, I'm not providing legal advice. But I would talk to your attorney and really walk through the application that they've created, and let that run its course, and see where it takes you. I would be very cautious not to provide legal advice, but to show you from an examination standpoint, there's a lot of reasons for how applications are drafted, and not only in regards to the prior art that's out there, but in regards to the technological advancements that may happen in that industry. That's dancing around your. I got to be careful. I cannot. I like my job. I want to keep it.
Yeah. No, I appreciate that, and that's kind of what we assume too. Is that we're not. This is our first time through, so they must know what they're doing. So we're not questioning it too much. We're just like this. We don't understand our own patent.
Thank you. Thank you for your question.
I have a few general questions, but I want to give a second to any, any founders have specific questions that they want, other things they want to ask.
Yeah, hey, Maddie, this is Jeff Bennett here. Can you hear me?
Yeah.
Yes.
Yeah, so this is kind of a multi-part question. We did a freedom to operate back in 2020 review with our attorney, and our attorney came back and said that based on that effort, there's nothing that we should be worried about in terms of our design. So we moved forward with that. Back in January, we received FDA clearance for our product. And a week later, one of our competitors served us with a patent infringement lawsuit. So we're currently in that lawsuit, and we're trying to determine, what can we do to start selling product. We're a startup. We've got one product. We felt we'd done the analysis necessary to make sure that we're free and clear, but obviously that's up for interpretation. So this competitor served us this patent. What can we do, if anything, in terms of selling a commercial product as this effort is going on right now?
So again, cannot provide legal advice, and this sound like a broken record, but I can provide you direction. There is, I mentioned this earlier, the Patent Assistance Center. That Patent Assistance Center, and maybe Marilyn can drop the link in the chat, but that Patent Assistance Center is actually manned by people who have retired from the office. It's not, I love my chat bots. I'm not discouraging or anything, but it is actually manned by live people who are either people like me, senior officials in the office that have retired and now come back and helped, or it is manned by even ex-examiners or legal who have come back and wanted to say, I want to give back. So I would encourage you to call that number. We do have people who have retired from the Office of General Law within the agency that can provide some guidance. I cannot, in my current position, give you any guidance on that. I would refer you back to your attorney. I know that's not an answer, but it's the answer I can give. But I would refer you to the Patent Assistance Center, who can, and they're open from 8 to 6, I believe, every day except Friday and Sunday. Saturday and Sunday, excuse me. I would refer you to them because that is a legal question, and it's not really a policy, but a legal question, which I cannot talk about or give an answer to.
Yeah, I understand that. Maybe you can't even answer this question. As a startup, we're limited in funds, right? And anytime you have a patent infringement case, that's going to make it, more challenging from an investment standpoint. What resources are out there to help startups like us incur the expense necessary to defend that? Because it could get very costly very quick, and we just don't have the capital for that. And therefore, having a patent infringement case, cloud over your head makes it even more difficult. So, what resources are available?
Right. So, again, there are I don't know. To be honest, I'm going to give a flat out answer to that one. I don't know. Most of the resources that I'm aware of are usually the incubators, accelerators, incubators who are, supporting startups from either helping them bring to, I say, commercialization or a workable product, an MVP, a minimal viable product, to your accelerators you already have that MVP, and now they want to help you further accelerate that commercialization aspect of your company. And then you have the SBA, SBIR, SCR. That's really not what you're asking for. You're asking for, is there really legal assistance, either free or minimal cost, to assist you? I am not aware, but if Maddie, you send me, if you give Maddie your information, I can look into it. But again, this is one of the things I have to step back from carefully. But again, there may be things out there that can assist you, but I would have to do some research and get back to you. But if you send your information to Maddie and Maddie, you send it to me, I will definitely reach back out.
Okay. All right.
All right, Brian, you got your hand up?
Thanks, Maddie. Darius, I got a question about like multiple innovations. So if there's one thing I know about entrepreneurs, it's that they rarely have just one good idea. And so let's say, you know, an entrepreneur receives an issued patent and they have another idea. Sometimes a new innovation might be in a totally different area and they can just pursue patent protection there. But sometimes the innovation is like, I would say derivative in a way, or it like builds upon the original. Do you see, kind of going back to your comment earlier, like if it builds off of an earlier innovation, does that original patent provide some protection, or do you often see innovator that tries to get a second, more narrow patent to cover this additional innovation? I guess my concern would be, can your original patent block yourself ever?
No. Okay, so the direct answer, no. There's a term there's a lot of derivative. There's a term it's called a continuation in part. In part, you're continuing in part. And what that means is you have your earlier filed application. Let's say it's, let's give it a date, date 2025. Now, that application may have gone to patent or not. Let's say it went to patent, but forget about the patent date. Don't really care about that right now. It's when it was filed. It was filed in 2025. But now it's like, oh, I got this new idea. I can add this feature to it that wasn't there before. Continuation in part. So you file that new application. Well, is that from 2009? Or does it go back to 2005? It actually goes back to 2005. And no, that application that you filed, it doesn't count against you. It's yours. Assuming everything is equal. Saying, you know, you're not different, all that good stuff. Assuming everything equal, so it doesn't count against you. You have that earlier filing date. You're linking that. It's a continuation in part. It's not a separate application. So it depends on how you file that new application. It depends on how you file it. So thanks. I would say directly to your question, no. And that's what we want. Remember I talked about that ideation cycle? We want you to ideate. We want you to continue to ideate, continue to advance your product, service, whatever you may have. So, hopefully that helps.
Very much so. Thanks.
Nice. Other questions? Well, I have a couple questions of my own while the founders brainstorm. Many early stage founders, you know, they're, like we've talked about, they're really strapped for time and resources. We touched on this a little bit, but what are the first steps they should take to protect their IP without breaking the bank?
This is kind of hear this a lot when I go out because it can be expensive, right? It can be expensive. So before I put that money out, and what should I do? And then we can get into money in a second, but you need to understand what you have. I don't know any other way to say that. You need to understand what you have, whether it's a patent, a trademark, or a copyright, or maybe you need both. Maybe you need a patent to secure that product you just made, but you have this business surrounding it that you need a brand. You need to brand it, which is the copyright, a slogan, a name. So you need to understand what you have, and that goes back to that IP identifier tool. That goes back to maybe looking at patents pro bono programs, or law school clinic programs, which are free. That gets into some of that cost, deferred cost, or minimized cost. So once you understand what you have, what are the next steps? Understanding how to protect it, if you will, the pathways to that protection. Again, whether it's pro bono, whether it's law school clinic, whether it's pro se. I'm not going to dictate one way or the other, whether it's going just straight to a patent attorney or agent. I'm not going to dictate which is better because that gets into your business strategy. And it also gets into business strategy in regards to also kind of taking a step back, whether you want to patent a trademark or whether you just want to go with a trade secret. And again, trade secrets are only as good as their secret. So you just want to figure out what is your business strategy, because that's a cost. It's a cost going in for a patent or a trademark. It's a cost. And then I think the biggest thing is you got to file. I've heard so many horror stories where you built this great company, working with the chamber. You built this great company, you built this great quote unquote brand, but you haven't really branded it. So now someone comes and takes that product, someone comes and takes that brand, and guess what? You're out of luck, starting all over again. So I've heard horror stories and I've heard success stories. So keep in mind, it is important not just to file that patent, but to consider from a business strategy whether or not you should be branding your business, your product, or whatever you have. Again, I'm not giving legal advice. I'm just, or I'm not pushing patents or trademarks. What I am saying is, though, it is something to consider for your own respective business strategy. So again, directly to your question, Maddie, I would say, one, understand what you have, understand how much it's going to cost, going that direction, whether it be pro se, whether it be attorney, whether it be agent, and then understand how to file. You got to file it. If that's your choice. Again, if that's your choice.
Sure. Yeah. Another question from one of the founders here. Can they work directly with the USPTO office to get a patent instead of working with a law firm?
Again, we don't provide legal advice, so the direct answer would be no. The indirect answer is yes, you can. As I said, patent assistance centers, trademark assistance centers, they're all out there. So the direct answer is no, we don't provide legal advice. We can, but we do, as I showed you on that site, provide invaluable resources to assist you along your IP journey, from inception of an idea, understanding what you have, to securing the intellectual property rights and protecting them. So we do provide you resources, trainings. I didn't talk about the trainings, my goodness. And maybe I'll just take a step back and allow Marilyn to chime in, if she's out there, but chime in on the types of trainings that we have, because there's a plethora of different types of trainings, from IP basics to Path to Patents, which is a multi-series type of training that we give throughout. So there's multiple different things out there for you, but no, we can't. When you say work directly with the office, I take a step back. I want to be clear on that one. No, you cannot work directly with the office to file your application, but indirectly, we provide you resources, trainings, and guidance to assist you along your journey.
Mm-hmm. Thank you. Yeah, and Amita, maybe you want to look into connecting with Legal Core, because they do offer no cost legal assistance to companies looking to file, or work with IP.
Yeah.
And just real quick, that's the IP, the Patents Pro Bono program does work with Legal Core. Every state is different for the Patents Pro Bono program. For this state, it is Legal Core. Yeah, just keep in mind that, and again, law school clinics, don't forget about the law school clinics.
Yep,
That's
good
also
point.
an invaluable resource.
Yeah.
Yeah, I think the University of Minnesota, Amita, has some legal clinics. And
Maddie,
also,
I did connect with Hamlin, University of Minnesota, St. Thomas. It depends on when, sir, Mr. Banks, they're offering a course. Depending on that, they hold their legal clinics. This year, none of them are offering, so we don't have that facility this year in Minnesota.
Okay.
And Legal Core does do its bit, and we'd love to get a sense of where to look for the trainees, just so that we do a lot of the work before we go to the law firm. They're horribly expensive for us.
Sure. Yeah. Understood. Another question from Jeff. What are the pros and cons of asking for a re-examination of an issued patent?
Ooh. Jeff, not touching that one right now. I will bring back some experts to touch that question. I appreciate it. I do. Let's just say I'm not going to touch that one. I'll bring back some experts. Maddie, if you call me back, I'll definitely bring back some PTAB judges and others that can better articulate the ins and outs of that. But I'm not going to touch that. I'm going to step away from that.
Fair enough. Are software algorithms patentable or trade secrets?
Interesting. Whoever presented that question probably knows about Uber, right? And their software algorithm was a trade secret that got out because of one of their ex-employees. So yes, they are. And actually, one of the technology centers that I worked in actually does look at algorithms, and yes, they can be. They are per se not unpatentable, but it's certain things you have to do, Alice, to make them patentable. So per se, they are not. And yes, they can. Yes, they can be trade secrets. But again, a trade secret is only as good as the secret.
Got it. Let's see. If a company or founder decides not to patent and finds another company that tries to patent an already disclosed technology, what is the potential course of action to ensure that a pre-existing technology continues with the minimum potential for litigation?
Sorry, Maddie, say that again. You follow that?
Yeah, Patricia, would you be willing to clarify your question a little bit? So if a company or founder decides not to patent and finds another company that already has the disclosed technology, what is the potential course of action to ensure that pre-existing technologies continue with minimum potential for litigation? I think we could use a bit more
about infringement. It's about it's kind of okay. I think we're touching on infringement because so you have an idea. You have not even a product. You have an idea. I'm assuming because you haven't patented it, so you have an idea, but this other company is already doing something in that space. So
I can clarify the question. So for instance, a lot of corporations that I know will end up disclosing in a research article, a specific technology that they intend to use. And so they make it open for others to utilize that technology as well if they want to commercially develop themselves. So it's basically open.
Open source.
What was that?
So you're talking about open source?
Yeah, so it's out in the market. Everybody knows that it's already being used, but somebody comes in and decides to patent something that's already been disclosed and already been commercialized, potentially by one or more companies.
You can't do what you. It's a non-starter. You can't patent. Okay, so there's two different. So you are just kind of talking a couple things here. One's infringement. One's whether or not you can patent something that's already been patented. You cannot patent something that's already been patented. You can look at.
But it would be something that wasn't patented, but it was disclosed in like a research article or something out there in the market that to ensure that it would not be patented.
Okay, so I'm putting on my examiner hat, and I'm saying I would have found that document, whether it is an article, a postdoctorate article, or whether it is online, because we have multiple databases. I would have found that article, and I would have used it against your application. So you would have never gotten that.
Okay, so then if you do actually see something that happened to somehow get through, you can always send them the article to show that it was already disclosed and then question that patent or
so
let the patent.
Remember I talked about that office action so an application comes in the door and then it goes on that off ramp to the examiner for examination, and they can write a rejection or objection. In that rejection or part of those documents that go back to the attorney, you would have something called an IDS, an information disclosure statement that the examiner is responsible for. And in that, the examiner would provide that document or documentation for the position that they're taking. And that would be the document. As long as that document meets certain criteria, and I don't want to get into the muck of it, but it meets certain criteria, it can be used against that applicant or against that application, excuse me. Does that make sense?
Okay. Yes, thank you so much.
Uh-huh.
Other questions? Okay, well, I have one more then. What are some red flags or common IP pitfalls you see among early stage companies?
I can't remember the lady I just talked to, but disclosure. You're disclosing something without protecting it. Whether it be you're this, and I see this sometimes in the universities where they're so excited about that new, the graduate student just finished his doctoral thesis and now goes out and talks about it. Well, guess what? Good luck on trying to protect that a year from then, because you just put it in public purview. So disclosing without protection, that's number one. And again, aside from trade secrets, not understanding what IP you have. You just invented this great product. You have this great business. You put the product out there, but you never got a brand on the business. So now someone comes in, takes your name, and how should I say, re-engineers Brian and adds that in part or something, and builds over your whole business model. You're wiped out, and there's nothing you can do. So, and that goes the other way too, where you got this great brand, but you didn't patent the product. So again, I would say not understanding what type of IP you have and how to protect it. And then finally, not understanding the pathways to that innovation ecosystem. And again, that innovation ecosystem, it's huge. You got everything from the universities, the government funding bodies, the incubators and accelerators, the market and consumers, the investors and venture capitalists, the corporations, and industry partners, all of that. Now, I didn't even mention the patent, trademark, and copyright services. You got all that playing in that ecosystem. It is a lot, but you got to take a step back and understand what is your pathway, where you're trying to go, and then leveraging the tools and the funding avenues, resources that are out there to make that to make that pathway a little bit more easier to traverse.
Got it. If a claim is found invalid by an examiner and rejected, how much opportunity does a founder have to amend the language and invention itself?
Great question. 2 bites at the apple. Yep, 2 bites at the apple before you go to either appeal or abandonment. Okay, what do I mean by 2 bites at the apple? Application comes in the door along that roadmap. The examiner picks up that application, examines it, has whatever issues they may have. It goes back to the attorney or applicant. They respond. Second time, this is the second time it's going back to the examiner. The examiner then sends something called a final office action back to the attorney. The attorney at that point, again, can argue whatever, but it's only 2 bites at the apple. 2 bites at the apple, you either go to an abandonment, an appeal, or you can go to allowance, but 2 bites at the apple.
Thank you. Other questions?
Darius, how many pro se applications do you see? Is it common or not so much?
It depends on it, Brian. Depends on the technology. More complex technology, probably less complex, a little more.
Yeah.
But it's I don't want to give it a number because it really depends. It depends on the technology. It depends on the company. Yeah, and not to call out one company or other, but if a company has an inventor has a very, very simple invention, but a crowded technology, they might want to ask an attorney to assist them to read over technological advancements in that area. So it depends. You'll hear that a lot from the office. It depends.
Yeah.
It-
I've
it-
always
it
used an
depends.
attorney, but I've heard of some innovators, well, actually more on the trademark side, that have gotten trademarks without an attorney. But I know that's not really the topic of today's
No, but
job.
to your point, yes, there are a lot more people who do it themselves. Be honest, my daughter has a trademark. I did not help her, did not help her in any way, shape, or form. She did it on her own. Then she let me know. But yeah, I mean, it depends on someone's willingness. The super soaker, the gentleman that did the super soaker, he did it on his part time. He's a prolific filer and inventor. So. Matter of fact, I think he just invented a new battery for EVs. So his company, I should say. So I think it all depends on the inventor, the entrepreneur, the small business, what direction from a business strategy, business planning they want to take. But it's at the end of the day, it's all about staying on that ideation cycle and continuing to advance your business.
Let's see, one more question here. Do we need to renew the patent? If so, how often? Is the first part, and then can they get a global protection when they get it the first time around itself? Is it more expensive? Do we need to specify the global area clearly?
Right. So I'll take it. The first one, can you renew? You don't renew a patent. A patent is 20 years. It's 20 years, and then it's in public purview. When I say public purview, it's no longer it's in the public. The public can use it. 20 years. Now, to Brian's earlier point, you can file continuations in parts, which kind of okay. So this in part now buys you another X years. This in part buys you another X years. But you can't renew a patent. You can't renew it. Now, remember I said earlier in one of the slides, a patent is not global. All right, it's territorial. So if you get a patent here in the United States, that doesn't necessarily you have the same patent in I'm going to make up a country. Pakistan, so I don't get in trouble. You would have to file and go through something called the PCT, which is the Patent Cooperation Treaty, and file that with WIPO, the World Intellectual Property Office, and then you can get kind of coverage. And you'd have to identify, I think to the point, you'd have to identify the countries that you want that application filed in. Okay. So normally you would get a patent here, and then you would request through normal routes to get a patent in other countries. And again, you have to designate what other countries you want when you go through that process. Okay.
I followed up. Countries or regions?
Countries. Not to call out any country, China, Europe, Germany, Brazil.
Got it. Okay. We have 10 minutes left, and of course I want to respect Darius and Marilyn's time. Last minute questions.
Hey, Maddie, this is Marilyn. So, of course, I don't have questions at this time, but I know as in the chat, you all have seen me pasting some links, some resources here, and hopefully these will be helpful to you, right? Many of the links that I pasted in the chat pointed to some of our more basic resources. But as I see from the conversation and from the questions, we have a very sophisticated audience, which this is wonderful, right? And hopefully Darius has been able to bring that expertise and answer some of these questions, balancing on that very high tightrope of legal advice. But I did just want to highlight a few things, which I did enter the link for our IP attaché. So we do have IP experts located around the globe that can at least give you information about those markets, information including, um, you know, not only the filing assistance or the application process there, but there may just be some nuances, right, where there isn't a one for one type of process here in the US. And so if you are thinking about filing for patent, trademark, copyright protection, and there are other types of IP globally, and those resources can be found on that on the WIPO, WIPO site that Darius mentioned. Um, I did want to circle back to actually the question about, some of the pitfalls that independent inventors and startups, some of the pitfalls that they fall into, the disclosure without protection. Um, when you're filing, if you are going to file pro se, ensuring that you are doing a comprehensive search for trademark as well, right? Those comprehensive searches are critical to your IP protection process to make sure that you aren't unintentionally infringing upon patents or trademarks that have already been granted or registered. And so we do have resources. I am going to paste into the chat. That's the one link that I didn't. We do have a number of trainings, including patent basics. We have a path to a patent course. And so if you haven't already filed or you're looking to refresh your knowledge on what that path to a patent is, we do have that. That's an 8-part series that refreshes or restarts every quarter. You can jump in at any time on any of those sessions. We similarly have our Trademark Basics Bootcamp, which is also an 8-week course, refreshes every quarter. But again, if you want to dive into the specifics of the trademark filing process, our Pro Se Assistance Center, I did provide some links on that. So if you would like to file on your own without an attorney, we do have a Pro Se Assistance Center where you can call and speak with someone about filing, getting clarification, not legal advice, but clarification on the steps as you're completing that application. Let me, before I forget, paste this in here regarding our events. We have a business unit, also the Office of Patent Stakeholder Experience, OPSI, and they put on some more in-depth trainings, as you may see, the STEP program, for instance, where there is Learn to Think Like a Patent Examiner. These are typically smaller classes because they do provide experts that go in depth about the subject matter. They also offer courses. It may be like a 3-day course about filing your patent application, not legal assistance, but very comprehensive information so that you're more informed as you intend to file. Or many of our stakeholders report those types of trainings will also help you have perhaps a more efficient or streamlined or informed conversation with your attorney, right? I know earlier in the conversation, right, someone mentioned it costs like $1,000 to talk to your attorney each time. But if you can find these resources prior to, consulting with your attorney, really getting informed and understanding what it is that they're laying out. Maybe it'll save you, maybe it'll shave off 15 minutes, right? $250 or so. So I just wanted to, point that out. I will enter into the chat as well my email address. So if there are some questions for Darius, myself, in terms of resources or questions where we can point you to some experts, please feel free to reach out to me. I'll be your first point of contact as the regional outreach officer. And of course, I'll work with Darius to make sure that they're going to the right business areas. We're getting you those responses as we can, or providing the appropriate resources.
Amazing. Wonderful. Well, thank you both so much for helping us out today, answering all of our questions. This engagement has been incredible, and your resources are much needed for our innovation community here in Minnesota. I have all of the links that Marilyn shared, and I will send them out to all of the grantees, hopefully this afternoon once this recording is ready to go. But thank you all for joining our Friday forum. Thank you again to Marilyn and Darius for sharing your knowledge, and enjoy the rest of your Friday.
Bye.
Thank you. Bye-bye.
Bye.